All right, Michael, so we'll wrap up with the gun conversation that you had initiated in your rant, but I've got a question.
We got a caller. Let's take a caller real quick. Caller, you're on the air.
Hello?
Hi, go ahead, caller.
Yeah. Hey, Michael, this is John. How you doing?
Good, John. How are you? How's everything going tonight?
Oh, I was just listening to the show here. I just wanted to say thank you for the court here, and I would agree with you that if it does goes to trial, there is something wrong, because I'm just floored that we're even going this far, you know.
That's a good segue into a question that came down on the MMMA about how a card holder should answer questions related to their medical marijuana status should they be asked them during a jury voir dire.
That's a good point. I think that this is a very important point that needs to be spoken about, and I've ranted a little bit about it. But the idea here is that medical marijuana patients, caregivers, people that believe in marijuana reform should insist on participating and want to participate in jury duty. They should not be thought of as individuals that should not be participating in the process of rendering a fair and just verdict. The issue for any juror that is going to sit in judgment of someone else is, can you put aside your political beliefs, your religious beliefs, your preconceived notions of the world and what you think it should be, and listen to the evidence and apply the law that the court gives you and render a fair and just verdict. Madam, who's been married to the police officer for 50 years and has only heard terrible things and how the police are always right and the police never make mistakes, and the police, if they say it once, you don't have to question them, and anyone that asks a police officer a question while they're in the stand is bad. And she's heard that for 50 years of her life, as she said, across the kitchen table and had dinner with her lovely police chief husband. And when she gets onto the jury pool and is asked the question, can you be fair and put aside the fact that you've been married to a police officer for 50 years, she's going to say yes. Of course I can. I can be fair. I'm a law-abiding citizen. I can be fair. I can render a just and fair verdict. Sure I can. The point that Chad's making is that I've been in that situation where we're trying to pick a jury and someone raises their hand and says, I think marijuana should be legal. There's no way in the world I would ever convict someone of marijuana. I could never be fair. I would have to find them. Couldn't even judge that.
No, I'm talking about even more straightforward. A person that wants to get onto a jury, wants to do their duty, knows that they can be fair, understands the Michigan Medical Marijuana Act, and they're about ready to go serve, and the prosecutor asks during the voir dire, are you a medical marijuana patient or caregiver?
I think that it's an invasive question. I would object to its relevance. And, of course, it would seem like it's very relevant. I would object to privacy.
What if the defense lawyer does not do that and you are just a juror?
Well, it's an interesting situation because it's really no one's business. And I don't think that they can compel you to reveal that information. It's private. It's privileged. The real question would be, is anybody of the state of mind, or they know someone or who is a medical marijuana patient, because of that, it's going to make them so they can't be fair or just. That's the question. Not, is anyone...
So you would say, yes, but I can be fair?
Yes. Of course.
So immediately qualified, yes.
That's
because you can't say no.
Well, you say because they're misleading and lying?
You could refuse to answer?
Yeah.
But
I don't think the question
then everybody
should be
knows the answer.
But and then you're going to get bumped.
Right.
I think it's irrelevant. I think it could be asked in a way that doesn't... I mean, I would never ask that question because...
Right. This would be a prosecutor asking the question. Somebody on the MMMA posted that it was on the jury selection form. Do you believe that medical marijuana should be legal? I think was the question.
That seems ridiculous. It is. I mean, I think the
human rights issue.
Well, I think the inquiry means, are they going to say, does it matter? I mean, if they don't have a medical condition, that's not going to allow them to sit for a certain number of days. That's a question, but it's not because of what their medical condition is. I think it's really dangerous territory. I find that very, very offensive. Jamie, what are your thoughts? I didn't mean to cut you off, Jamie. You want to come back? Come back, please.
I'm not aware of the question. I was so hurt by what happened.
Hold on, I put John Roberts.
So it's an immediately qualified yes. I am a card holder, but I know the law and can be fair, or that I can be fair as I'm instructed by the judge.
I mean, first of all, it was ridiculous if someone's asked if a lawyer said, "Does anyone a medical marijuana patient? Please raise your hand." I think I would say objection. There's a better way to ask that.
Sure, but not all defense lawyers
okay, fine.
are necessarily.
So then it's asked, and I think the judge would even jump in potentially. But nevertheless, let's say that they ask it, and first of all, the prosecutor and the defense attorney can each get rid of, if it's a felony, 5 jurors for any reason. They're called preemptories. Which means that identifying yourself as a patient, I mean, someone may not want to. They could say, I refuse to answer the question. I mean, I don't. It's no one's business. But then, of course, you're going to know, and then you're going to be removed from the jury. Anyways, but so yeah, we don't want to lie. We don't want to commit perjury. I would, it's I would say a problematic situation. I think that the first thing is to be objective, or at least say it in a way. Is there anything about your experience as either a patient, caregiver, or knowing a patient or a caregiver that's going to affect your ability to be fair and just in this case or render a verdict? No. If someone says yes, what is it? And then you engage them that way. But I just don't think that a person should be removed. I would even, if someone removed somebody for it's called a Batson challenge. It's gone to the U.S. Supreme Court. It's when you're picking a jury. This has happened in a situation where it's a pretty much all-white community, and it's a black defendant, and each side is allowed to remove 5 defendants if it's a case that has, if it's not a capital case. If it's a capital case, you get 12 preemptories, but you start with 5 preemptories. And, the situations where the white juror, white juror after white juror, and then finally there's one or two of the black people from the jury pool gets into the jury box, and they ask questions, and the individual gives answers that there's nothing about their answers that would suggest that they couldn't be fair, and for what appears to be no reason, the prosecutor removes them as a preemptory, meaning it would appear as if they're doing it only and exclusively because of the reason that they're black, let's say. And that's been challenged. Prosecutors have to be careful about that because the goal of the jury selection is to have a equal, a fair jury that is a equal cross-section for the defendant, and I mean, one could argue that you're not getting a fair jury if you're eliminating patients or caregivers just because they're patients or caregivers. But, and I don't think the argument's fair that they're just because they're patients or caregivers means they're going to find somebody not guilty. I mean, we would like to think that they'd have, compassion and understanding, even though they're going to be asked to follow the law. And at the end of the day, beyond a reasonable doubt is a personal thought. Really is something that an individual brings in terms of what is reasonable beyond a doubt.
Here's another angle. You've got a room full of other potential jurors, and you're asked under oath whether or not you're a card holder, and you actually don't want to reveal it because you're in a room full of people that know you in some other capacity.
Well, I maintain that, why would it be any different than if you have a CDL license or carrying a pistol permit or some other type of license? I mean, individuals...
So at that point, it would be the refusal to answer and get booted from the jury option would be the best.
If they don't want to lie and get caught, I mean, you can get into a lot of trouble if you're misleading on a jury and it's found out. I don't want that to happen, and I would never advise someone otherwise. What I am saying is that, just because, my position before was people in the medical cannabis and cannabis reform community should want to get on juries, and they should understand the questions that are being asked, and independent of what they bring into the courtroom, personal views.
They just may not want to be revealed.
But as far as the patient, I mean, if you don't want to talk about, I mean, it really shouldn't come up. That's why I'm having a tough time with it. I can't think of a justifiable reason. Sure, it could happen, and
it shouldn't have been put on the juror form.
I would. Who's the lawyer? I would. You don't know what it is. Let's see. Of course not. I wonder if that's a question for all jury forms that they may be sending out now.
Said it was in a different type at the bottom of the jury form, a different font or something.
What jurisdiction is that from? That's really the inquiry. I wonder if that is specific to the case or a policy that's been employed now. I mean, that would seem to me that they're trying to create a situation where they're eliminating from the jury pool medical marijuana patients and caregivers intentionally. I would have a real problem with that. I want to know if they know what jurisdiction it's in and out of what court the jury questionnaire was sent from. All right, while we're doing that, should we take another? Jamie, are you still here? Come on.
Yes, I am. Are we ready to get back on to what we were planning on talking about tonight, or
yes, I'm sorry.
Are we still talking about this?
Please, let's get back into it.
Well, there was kind of a wrap-up question that somebody sent to me about the 783. I wanted to address real quick, and then a question based on the guns. And that wrap-up question is about an apartment building with several units. If it is okay with the owners of that apartment building, can every single unit then have full gardens in it?
I think you're running into trouble, and that's the point of this in leasing and putting into writing those particular factors. I think that the federal government, if it's going to, they've made their point that they don't want landlords, large-scale grows in any of these specific locations. Now, it's for medical purposes and it's well managed. I think, it's possible, and that may be a direction that this may go. But I can't help but to, on behalf of the landlord, the owner of the apartment, have concerns for them and their liability, that if they are writing in a document an agreement for these multiple persons to grow marijuana that maybe at account that interests the federal government, I think that is a document that will be used and could be used to come back and haunt you later on. I'm not suggesting that people, private property owners, not contract for what's allowed or not allowed, but if they're going to engage in the activity and the landlord knows about it, I think they have to be careful in terms of how they acknowledge it. And I would avoid, if I were them, I would avoid putting it in writing. I think it could be done very easily with a verbal agreement. There's no need for anything other than that. And from the landlord's perspective, and from a patient or caregiver's perspective, I guess if it's in a industrial or circumstance like that, I think that the landowners, property owners, has risk. So I would avoid doing that, and just it's better what they don't know in those circumstances. And because with the approval of the initial behavior, you can get caught up in what they call the wheel, the entire wheel as it moves forward down the road, and you may have very, very little to do with it, but you and your one little involvement, the spoke of this wheel, which would be the lease that you agreed to that is engaging in this activity, even though you have nothing to do with it and may never have any kind of pay above whatever the lease is. The lease, rent maybe getting paid from, this behavior that you have no idea about. So I do think it's very risky for the landowner, and they should go about it and just basically not put anything in writing. And just
they don't have to put it in writing. They just have to not disallow it.
Right. I don't have a problem with that.
But they could do it, but they still run the federal risk, and they would hope that federal policy to kind of leave the states alone would be active, but there's no guarantee because of the state law. Is where the risk is, because there's so many plants in that building. Is that what the issue is, or is it whether or not they put it into the lease?
My concerns are at the federal level if you have a lot of plants together
in a building like
that. That's the number one thing. And if that's the case, and any one person steps out of line, everyone steps out of line. So I'm saying if you're going to go down that road and be accountable and put in writing or even, the more that the owner knows. I mean, listen, there's one way the feds would look at it. It's a RICO. You got multiple grows in one particular place that has been agreed to and encouraged and participated in the owner. One person selling it out, doing something illegal out of there. They catch that person. They catch all this other stuff going on there. It may appear as if it's not really going on, but that's not where the feds go. You know what they do? They throw out a big net. They get everyone involved, and they go after the people and they want the building. So it's dangerous in that regard. Will there be a time when this will not be an issue? Yes. Does the building owner, can they know about it? Sure. But not something that you want to record. And I would, what I mean is, they can approve of it, not put it in writing. But their position is, if challenges that they really don't know and it can't be proven. Let the caregivers say it's never going to come up as an issue. You know what I mean? Like, it really shouldn't. The caregivers got their own issues. The patients can have their own issues. They're dealing with that. It should have nothing to do with the landlord. The landlord really wants to just rent the property and get their rent from filling up the space. What the patient and the caregiver do there should really be their own business. And the one thing the landlord wants to do is really not be knowledgeable, other than maybe that it's going on. They assume that their patients and caregivers. I think that's the most of it. But anything beyond that creates risk for the caregiver. For the landlord, because of they don't know what the behavior is. Some people may be working a risky Section 8 dance out there, and all of a sudden, that means that, whatever. I could make up all kinds of stories of what that might mean. But the point is that kind of behavior can, and even at the state level as well.
Okay, that's understandable.
It's a compelling argument.
Yep, I think
right?
so. And all right, so just to finish with the guns issue, that you put a lot of good information on the beginning of the show, actually, toward the end of your rant. And this question is specifically asked to me earlier today. It was a husband and wife. Husband is the caregiver, wife is the patient. The husband is seeking a concealed weapons permit. Wants to know if he should give up his caregiver license. They do grow a few plants, and they never really have a more than 2.5 ounces of usable marijuana around or in possession.
Well, I've litigated this issue, and it's come up again in another case that's even more compelling. I think that the issue with the CCW is a fascinating one. I was talking a little bit about it earlier, and I have heard many horror stories of patients being forced by the county gun board to relinquish their pistol permits so they can no longer carry them concealed. And it goes on, it continues to go on until someone does something about it. We may have a case that I think may be the right one to really do something about it. But to answer your question, Jamie, when it comes to the caregiving, I believe that the caregiver does not fall into the fray or the exclusions or the basis by which the gun boards are denying individuals or revoking or suspending their CCW or pistol permits. What am I saying? I'm saying that if you're a patient, the gun board, I think, has taken the position that you cannot have a carrying of concealed pistol permit because, according to the ATF, anyone that uses marijuana, it's a dangerous drug, it's addictive, and the people that are using it are unsafe or unfit and outside of a class of individuals that would be expected to be able to hold the privilege of using a pistol permit. These are not my words. This is how the ATF has outlined it in their policies that somehow guide and direct the gun boards of every county, although it's a state legislated administrative agency written by the Michigan legislature and applies in regards to Michigan law. Now, the distinction in your fact pattern, Jamie, was that the wife's a patient and the husband's a caregiver. I had one particular instance where we fought this, and my client at that time was a patient and a caregiver, and had a incident in a jurisdiction where the where the gun permit was not gotten, but which was in Macomb County. Nevertheless, it was like a traffic issue. He got a couple of traffic offenses, and actually the card prevailed in the sense that there was no marijuana charges. He had a pistol permit. He did not have a weapon on him. What was weird, though, was that they directed him into a schoolyard, and they gave him a ticket for having controlled substances on a schoolyard. Anyways, we got the charges dismissed. But the bigger issue was that interaction with the police department resulted in them contacting the Macomb County Gun Board. So we went in for a hearing. I filed a bunch of motions. Our plan was that we were going to try to make the best record that we could at the gun board. People may or may not know this, but the remedy for challenging the gun board on whatever issues may be is you can appeal to the circuit court, and then you can appeal to the Court of Appeals and to the Supreme Court and beyond if they'll hear you. But we went and had a hearing. I remember Macomb's interesting because while the administrative gun board allows for and requires 3 individuals, the sheriff, the prosecutor, and some other appointed individual, not necessarily a government agent, most of the prosecutor's office will send somebody else to get their own representative, but Macomb County has a prosecutor designated for this, so it made it a little bit more fair of a fight, because if you're just dealing with a sheriff and you file pleadings, they're not going to, that's not even a thing for them. You're going to have to get over to the court, by getting your result, which is probably going to be negative, and you're going to go, because they're run by policy. There's no logic or reasoning. But this whole issue is one that's a policy that was developed without logic or reasoning. And I had filed these pleadings, and we were having a hearing, and we were arguing, and there's a lot of precedent that exists in other states that are on point with whether what the gun rights are going to be for people that are patients and caregivers, and are they excluded in any way. And the way that was played out in this particular hearing was that they made a distinction, and I believe, I don't want to give absolute legal advice, but I will tell you that within the next couple of weeks I'll have this more resolved. But the way the board at this particular time, this was in 2011, approached this was that they distinguished between the patient status and the caregiver status. In other words, they did not have an issue with a caregiver who was growing marijuana and who also had a CCW permit. However, the warning should go off for that combination of things, that even though you have a CCW permit, gives you a privilege to carry it concealed, I would be very, very careful about having it in and around your grow. In fact, I would suggest that you not do that, just to avoid the possible liabilities, as I talked about in the rant, of the felony firearm charge. As to the patient, in the case that we had, my client did not want to take his case to the Supreme Court. Why would he want to? Why does he have to deal with this ridiculous line? I don't blame him. He didn't want to be the poster child for this, even though it was the right circumstances. So the law remains, and until someone challenges this and someone puts their foot down and says, this is inherently unfair, that I've done nothing wrong, and for some reason the gun board has found out of my patient status, and then therefore they are going to revoke my status for the right to possess a pistol and conceal it for no illegal reasons. I did not violate any of the reasons that would prevent me from getting the pistol concealment permit, and I didn't violate any of the terms of the license of keeping it, other than a federal government policy from the ATF that came out that said those people should not get pistol permits, and it's really offensive. So, Jamie, to answer your question, anyone dealing with guns, marijuana, has to know the risks of the combination of those two things is bad if you're outside of the act. If they want to avoid any trouble at all, don't even get engaged. But if they're going to, my position would be, I do not believe that the gun board has taken a policy of excluding caregivers from being from maintaining their permits. They should know about it, first of all. And second of all, if they do find out about it, absent, it depends how they find out about it. If it's because of a raid and the guy's got criminal charges, then they're going to revoke the CCW permit immediately. That's just the nature of the beast. They take that if you have criminal charges. But if it's just because they learn of him being a caregiver, I'd suggest no, and I'd suggest even more so that it shouldn't be found out. And I think that's one of the particular more important facts of the case that we're looking at right now, is this possible poster child case as to what is going to be the remedy if we can identify that, in fact, someone in the law enforcement community disseminated patient information to the gun board. Or said another way, how does the gun board get information about patients that would warrant them revoking or restricting their license? And if there's an answer to that, what is the remedy for that patient who has been stripped of their license to possess a concealed pistol, and who is to blame, if anybody? Was that close to answering your question, Jerry?
I think so. I think that sounded good. And we are over. We didn't want to go over, but there shouldn't be much more. We should be able to wrap it up unless you want to go for another half hour.
I don't. I'm good. Chad?
I also don't want to go for another half hour.
All right, well, let's call it right there.
Yeah.
Thanks to all of our guests. I think we had a fantastic display of outstanding information and talent tonight. John Roberts, thanks for calling in. I'm sorry that we cut you off. I just didn't realize what time it was, and I'm glad you got a chance to get on there. We got a chance to chat a little bit. First, a big shout-out to Ian Elliott. Loved that young universityite. That's the fertile ground for reform. And good work over there. We look forward to hearing from him. Of course, our dear friend Robin Schneider and Josey Scoggin, thank you so much for your contributions. To the greatest producer in the history of Blog Talk Radio, Jamie Lowell, outstanding work tonight. Chad, thanks for sidekicking, and our best wishes for our good friend and Compassion Chronicle editor-in-chief, Rick Thompson. We understand he's not feeling well, and hope we'll get him back in the saddle next week. And for everyone else, thanks for listening. We're going to end it right here, and we'll see you next week. Be safe, and thanks for listening.